I'm attorney Phil Giacino, and this is Finding Common Ground here on Altice. You can see this show every Saturday at 10 a.m. on channel 115. Got a great show for today. We're going to cover two topics, and then if we have time, we're going to get into frequently asked questions. First topic is, what do you do when you need an attorney? You're going to interview an attorney, and it's actually an interview, just like a job applicant. You need to know if you're a good fit with that attorney. Do you trust the attorney? Can you afford the attorney? Is that the right attorney for your particular case? And on the flip side, what happens when that attorney-client relationship breaks down? So let's get to it. A couple of years ago, I wrote a book called Divorce: A Practical Guide, and I started out thinking about writing something humorous. And then as I got into it, I said, you know what, this is a very important topic. Divorce, orders of protection, family court. So I wrote it as a straight book, a little bit of humor here and there, but for the most part, an informative book. So if you read this book, you'll get information that you need from the beginning to the end, and even beyond the divorce process, appeals, what can be done to modify an order, and so on. I want to start the show with a quote from one of the chapters in the book. The chapter is called, "What We Have Here is a Failure to Communicate." And that might sound familiar if you watch the movie Cool Hand Luke, where the boss man says to Paul Newman, the Paul Newman character, Luke, what we have here is a failure to communicate. And this is a quote from Abraham Lincoln. Regarding communication, Lincoln said, "I determined to be so clear that no honest man could misunderstand me and no dishonest one could misrepresent me." So he wanted to be crystal clear. I use the vernacular sometimes. I say, I want to make things idiot-proof. That means, and I don't mean to insult anyone, but it means I want to make it so clear that nobody can later say, I thought you said this or I thought you said that. And I also write letters to clients and other attorneys so there's no misunderstanding. Now, a little while ago I said, what do you do when you need an attorney? The first step is sometimes you Google an attorney. Sometimes it's even better if you have a friend, let's say, that used that attorney and he says, you use that attorney, he's great. Or he got me out of that jam. Or he did my divorce, whatever the case might be. But then you have to set up the consultation. Many attorneys, myself included, give a free consultation. So you go down to see the attorney. Now, before you go down there, you should know what your case is about. Obviously, is it a divorce? Is it a family court case? And find out if that attorney actually handles that kind of case. You don't want to waste your time. You don't want to waste the time of the attorney. Now, my staff generally will say, what kind of case do you have? So if you had a bankruptcy case, let's say, you wouldn't come see me. Or if you had a medical malpractice, you wouldn't come see me. But if you had a divorce, family court, and so on, criminal court case, I would be the attorney you would come to see. So you set up the appointment, and before you go down there, also figure out what kind of documentation you might need. If you got served a petition in family court, bring it. Sometimes someone comes in to see me and I say, do you have the petition? I left it at home. Well, it doesn't do me any good because I don't know exactly what the other side is looking for. I might have an idea. Is it child support? Is it custody? But I want to see the document. If it's an order of protection, how can I advise someone unless I know, is it a stay-away order of protection? Is it a refrain from? Does it include children? Does it not include children? I need to know that so I'm in a better position to advise the client. Now, that doesn't mean the client has to come down with a suitcase full of documents, but at least have a handle. I'll give you an example. When people come in on a divorce and I say, okay, is there a house? Yes, my husband and I own a house. What do you think the house is worth? I have no idea. Okay, how much do you owe on the house? I have no idea. Well, it puts me in a position where I really can't advise you what you should do with your house. If you said the house is worth about $500, we owe about $250, then I can kind of guess that there's about $250,000 of equity, and then I can ask the questions that'll help me or put me in a position where I can help you. I could say, okay, $250 equity. However, where'd the down payment come from? Oh, it came from the husband, or it came from the wife, or something like that. So it gives me information I need that I can help you and be in a position to advise you so that when you walk out of my office, whether you hired me or not, you're going to say, okay, I know what's going on with the house, and so on. All right. So, what are some of the things you need to look for in that attorney? Again, for obvious, does he handle that kind of case? That's an easy one. The second one is, can I work with that attorney? You want to be able to say, that's the kind of attorney I can work with. Because in a sense, it's an intimate type of relationship. You're not going to a deli and getting a sandwich. You're going to be working with this attorney. If the case goes to trial, you may be sitting next to that attorney for weeks. You're going to be on the phone. You're going to be doing a whole bunch of things. And in fact, my producer is going to put up a couple of things. I first want to put up Perry Mason. For you old timers, that was an attorney we grew up watching. If you're a millennial, you have no idea what I'm talking about. But he would always win his case against a prosecutor who was named Berger. And he would always have a gotcha question. And his client would be found not guilty. And the guilty person would be found out who was a witness testifying. Right? Then you have Matlock. Matlock is another kind of attorney. He has Southern charm and homespun wisdom. Then you have an attorney like Vincent LaGuardia Gambini, my cousin Vinny, who I think he specializes in representing Utes. But that's a different type of personality. And obviously I'm being facetious here. But there are very different types of attorneys, different types of personalities, cases they handle, cases they don't handle. Some have a sense of humor like me, others are very straight, and that's fine. You have to find out what kind of fit there is. And how do you do that? Well, when you talk to the attorney, ask him or her questions and see how they answer those questions. Do they look you in the eye? Are they evasive? I'll get back to you on basic questions. Obviously, if there's something very complicated or something new or not really well defined in the law, let's say, I might say, you know what, it could go either way, I'll get back to you. But for the most part, you ask a simple question. I make $50,000. How much child support am I going to pay for 2 kids? If the attorney can't give you a straight answer in about 10 seconds, maybe that's not his those cases are not in his wheelhouse. So you want a good fit. Second one is, do I trust the attorney's advice? What do I mean by that? When you ask the attorney a question and he gives you an answer, do you feel like you can take that answer to the bank? Or is he, well, I'm not really sure, I'll have to let you know. Now look, an attorney can't make a guarantee. When someone asks me a question, obviously there are certain, I could say, yes, you make $50,000, 2 kids, that's what child support's going to be. But sometimes the clients want a guarantee of something. And without knowing all the facts, like in an initial interview, I may not have all the facts, and I could say, well, it's probably going to be that, but I can't guarantee. And I often joke, I say, if you want a guarantee, I got to charge you more. Or my crystal ball is in the shop. Because if it goes to litigation and a judge has to decide, then I can't guarantee what a judge will do. I'm very good at saying what I think a judge will do and what likely a judge will do, but there are some times where, like, who's going to get custody? Well, if the other side is a drug addict and an alcoholic and beat the child, and the other parent is father or mother of the year, I won't be going out on a limb to say that good parent will win custody. But I always stop short of using the word guarantee. Does the attorney seem honest? Now, when you're dealing with lawyers, that sounds like a funny kind of thing to say. But you want your attorney to be honest. You want your attorney to have credibility. Because when you go to court, there are some attorneys where you say the name and the judge might say, oh, okay, that's what we're dealing with. Or, oh, okay, he or she is a straight shooter. You want that kind of attorney. You don't want the attorney to be lying for you, because if he's lying for you, he probably lied for other clients, and that kind of attorney is not going to have credibility in that setting, in a court setting. So does the attorney seem honest, straightforward? Are they going to fight for you? Are they going to fight for you in a way that's not just intending to churn litigation and create more legal fees? You want an attorney to fight for you, but also to be honest with you and say, look, you could pay me $10,000, you're probably not going to get custody based on the facts of this case. The other thing is, you probably want to hire an attorney that has an excellent reputation and that is known where your case is going to be heard. You could get the greatest attorney that ever lived in Schenectady, but he's probably not well known in Suffolk County. And he's probably not known to the extent where he might be able to maneuver better than, let's say, somebody from out of the area. All right, so that's not, a leap to say you want somebody from the particular area. Like, I don't go to Nassau County anymore. It doesn't pay for me. My case is here in Suffolk County. It's bad enough. Family court in Suffolk is in Riverhead as well as Central Islip. So I have to run. Today I had to run from one court to the other. It takes about 30, 40 minutes to get there. So you want somebody that's known, that can get to the court. You get somebody from the city and they show up 3 hours late because they got stuck on the Long Island Expressway. That's generally not a good thing. Any more than you'd hire me for a case in Manhattan. You wouldn't. I wouldn't take the case. So you want to hire somebody with experience, that has credibility, knows the court officers. If there's a custody case, does he know who the attorney for the child is going to be? I will know that here in Suffolk County. If you hired me for the city, I wouldn't. So that's why you want, generally speaking. There are exceptions. I once had a case that needed an outside attorney. It was in Nassau County where I got to cross-examine a sitting Supreme Court judge. No attorney in Nassau wanted to touch it. I took it and we got a good result. Because I wasn't afraid of what the judge, I'm not afraid anyway, but I wasn't afraid of what that particular judge might do to me if, let's say, he saw me on a regular basis. But there were some attorneys that are like, I don't want to touch that case. Can you afford that attorney? Always, always, always find out the fee structure. He's obligated or she's obligated to tell you. All right, it's going to be a $10,000 retainer or $5,000 retainer or $2,500. Is it a cap? Generally not. Could there be additional fees? Most likely. If it goes to trial, what could the trial retainer be? You want to know these things. You don't want to break the bank, hire the attorney, and when the first request for payment comes in, beyond the retainer, you're saying, I don't have it. That attorney at some point is going to get off the case. Unless there's monies down the road. Like, let's say a house is going to be sold, and the attorney's confident that when the house sells, he'll get paid. I get that situation often. There's going to be a house sold, the attorneys get paid. All right? So can you afford the attorney? All right? Can you listen to him? Will you take his advice? If you're not going to listen to the attorney, why are you hiring that attorney? It doesn't make any sense. I'll give you an example. Years ago, many years ago, when I was in my 20s, one of my first maybe dozen divorce cases, I had a client and we tried to work out a settlement, and I was going to get her about $1 million, $1.5 million. And the marital estate was worth $4 million, but she wasn't entitled to the whole estate because some of it was separate property, and that's for another show. And I've done shows about equitable distribution. So I said to her, take the 1.5 and run, because if it goes to trial, you won't even get $1 million. And she said, why are you saying that? You're not going to fight? I said, I am going to fight, but I have to be honest. It would be like a doctor telling you, you'll be doing handstands tomorrow, and meanwhile, that's never going to happen. You got to be honest. The attorney has to be honest, just like the client should be honest with the attorney. I don't like surprises. You don't tell me something and then I find out you want it in 5 other states and I'm trying to make you out to be a saint. I don't look good, you don't look good. But in the example, could have got a $1.5 million. She fired me. She hired another attorney, a very good attorney from Nassau County. They went to trial down the road. About maybe a year or so later, after the case went to trial, and I had lost touch with the case, I wasn't her attorney, by mistake, the court clerk sent me the decision, thinking I was on the case. They must have looked at the file and saw my name and said, oh, he's the attorney, and they sent it to me. So it comes in the mail. In fact, one of my assistants who knew about the case came to me and said, Phil, remember that case? I said, yeah, what about it? Do you know you had a deal on the table for 1.5? She ended up getting about $400,000, around that. Not even $500,000, about $400,000. And she went to trial. She spent a lot of money, and it didn't go well for her. In fact, she filed a complaint about that attorney. Whether it was warranted or not, I don't know. But she ended up getting $400,000. I think she appealed, and it didn't go well for her, from what I understand. That's a perfect example of if your attorney emphatically tells you something, it's generally a good idea to listen to that attorney. Because then you're going to spend a lot more money like she did and get a result. She ended up getting like 1/3 of what I could have got her because she didn't listen to me. And she went to an attorney, and the attorney sold her a bill of goods and says, I'm going to get you whatever. and it was never going to happen. So that's very, I call it the $1 million example. Very, very important. Now, there's a flip side to this. We talked about what to look for in the attorney, what to ask questions, ask all relevant questions. That's why you're there. Usually it's a hour meeting. And then you fill out an intake before you go in so the attorney can say, okay, there's a house, there are 2 kids and all that. So ask the questions, make sure the attorney's honest. If you hire the attorney, listen to the attorney. And then when you're sitting there, say to yourself, that man or woman sitting across from me, if I hire him or her, will I listen to that attorney? If you're not going to listen, don't hire the attorney. So the flip side is what happens after you hire the attorney and the attorney-client relationship breaks down. What do I mean by breaking down? Either the client or the attorney feels that it's not a good fit and it's time to part ways. Now, if the attorney wants to if the client wants to hire the attorney, it's pretty simple. I don't want you anymore. They sign a consent to change attorney form. If there's monies owed, that's a separate issue. That can be handled in a fee dispute. That can be handled in a lawsuit. That can be handled in negotiation. Right? But I'm just talking about mechanically what happens. So the attorney would sign a consent to change attorney form, and that litigant, that client, would be free to go elsewhere, represent themselves, hire a new attorney. If money's an issue, maybe they have the kind of case like a criminal case or family court case where they can be assigned an attorney, legal aid or something like that. What happens when it's the attorney that comes to the conclusion, I can't work with this client, or this client can't work with me? And it happens. It's unfortunate, but it happens. Now, there's a couple of ways to do it. The attorney can say, the relationship has broken down. You're not paying me. You owe me a lot of money. We had a payment plan. You stopped, or you're not paying me what I'm entitled to. I don't think there's any chance you're going to pay me, or you're not cooperating with me. Sometimes I call a client and there's an expression, they fell off the face of the earth. I call them, I send them emails, letters, whatever I have to do, and I can't get a hold of them. They've just vanished off the face of the earth, like they were abducted by aliens. I can't get them. I might even call another number. Let's say it's a young client and I have the mother's number. I call the mother. Can't get them. I don't know. Sometimes I don't get a call back, or we've had a falling out. I don't know where they are. What do I do? Well, at some point, I have to get off the case. If not just about money, but lack of cooperation. How can I represent someone that will not return my phone calls? Think about me not returning their phone calls. What would they do? They could file a grievance. They could complain. They could fire me. I would return their phone call. So the attorney can say to the client, who they can't get a hold of, but let's say email them a consent to change attorney form. Say, please sign this so I can be relieved as your attorney, and you could go elsewhere. If you're not calling me back, then how could you possibly want me? Or sometimes the client, I've heard, where there's almost a shouting match between the litigant. I've seen it in the hallway sometimes, not a pretty sight. And there it breaks down and you just go your separate ways. But what happens when the attorney wants to get off the case and the client won't sign that consent to change attorney form? What happens? The attorney is left with no choice but to make a motion to be relieved. That's a motion that the attorney makes to the court, to a judge, the judge handling that particular case, saying, these are the reasons why I have to get off the case. They're not paying me, they're not cooperating, they've badmouthed me, or they said something about me that made it clear to me that I have to protect myself and get off the case. Now, if an attorney has to make that motion, that client is pretty darn foolish. Because I only have to say those things to the court, and I don't say it to the other side. They just get the order to show cause saying, I want to get off the case. So all the nasty things I may have to say don't go to the other attorneys or the other litigants. So if there's an attorney for the child, if the wife has an attorney, and let's say I have the husband, the wife's attorney and the attorney for the child don't know specifically. They don't have the specifics as to why I'm getting off the case. They just know I'm making a motion. But the attorney knows. That's the foolishness of this. The judge knows. The judge will be told Why? Lack of cooperation, saying things, inappropriate things, or bad-mouthing the attorney, accusing the attorney of not fighting or something like that. Like if someone says to me, Phil, you're not fighting for me, and I know I am. Why would I want to stay on that case? Wouldn't make any sense to me. Because if that's what the client feels, I don't want any part of it. I'm going to say you're wrong, I'm getting off the case. So rather than sign a consent to change attorney form, you're going to make that attorney make a motion to a judge who's going to then know that you're not cooperative and maybe this case is dragging on because you're not cooperating with Mr. Giacino or whatever attorney you happen to have. So it's not advisable to make the attorney do that. Now let's just say you have an attorney and you say, I paid you a lot of money, there's still a balance. You have a right to get your money back under certain circumstances. If the attorney didn't earn it, you can get that money back. But that, in a sense, is a separate issue. If you feel that the attorneys are fighting for you, you might want that attorney off the case. That doesn't mean you can't file, let's say, a fee dispute to get some money back or to have the Bar Association, the fee dispute committee, say that attorney overcharged you, or he has to pay you X amount of dollars back, or he doesn't have to pay you. That you can do, but get rid of the attorney. But like for instance, if I hired an attorney, or I hired a doctor, or I hired an accountant, and they're not working for me, why do I want them to stay on the case? That would be idiotic. I would say, have a nice day, I'm taking my file elsewhere. That's what I would do. And that's what a litigant should do, because otherwise that attorney is going to have a sense of what you're all about, and you don't want that. So call the attorney back, say you want another attorney, you want to represent yourself, that's fine. But don't make the attorney make that motion. Now, let's get into what I call frequently asked questions. These are questions that I compiled, and I have hundreds, through the years when people have come up to me and asked a question, or in my practice, things that are frequently asked, where people don't know the answer. Now, I always try to keep things as simple as I can, but this is the law. So sometimes it is a little more complicated. It's like medicine. Sometimes you could say, take an aspirin and call me in the morning, or the person has a serious disease. Every case is unique. There are cases that are similar. Like for instance, let's say I represent a client in a petty larceny where they stole a toothbrush from CVS. That's an easy case. I mean, I have them attend the stop-lift program as long as they have no priors, as long as they didn't steal a lot of money, as long as they don't work for CVS. That's a different situation. That's pretty simple. I know what's going to happen. All right. Then you have the complicated case, like in a divorce, where the parties bought a house, it was in one party's name, then it went in another party's name, and then you have transmutation or commingling, and you have all these issues. That's more complicated. You need an experienced attorney to be able to help you navigate through that issue. So let's talk about some frequently asked questions. One question I get is, what is the difference between Supreme Court and family court? There are two separate courts, but there's overlap. There are cases where it can go to family court or it can go to Supreme Court. There are cases that you can only go to one and not the other. Why is that? What is Supreme Court and what is family court? Supreme Court, other than the appellate court, is the highest court in New York, a court of original jurisdiction. I'm not talking about the appellate division or anything like that. So car accident case, let's say you're suing for $1 million in a state case. You go to Supreme Court. All right? You are suing a neighbor over something. You could go to Supreme Court. That has jurisdiction unlimited. All right? Certain cases where it's $10,000 or $5,000, you can go to small claims court, you can go to district court, you can go to county court. But let's talk about what I would call family law type issues. Custody, child support, divorce, orders of protection. When can you go to Supreme? When can you go to family? Divorces have to go to Supreme Court. You can't seek a divorce in family court or any other court for that matter. You have to go to Supreme Court, the matrimonial part, over in Central Islip. They don't even have divorce cases in family court, in Riverhead. Family court, remember I said earlier, family court is also in Riverhead and Central Islip. Supreme Court, divorce part, matrimonial part is only in Central Islip. Those are the divorce cases. Can you go there for other types of cases? Yes, you can. But if it's, let's say, just child support, or let's say custody, you generally, if there's no divorce involved, you go to family court. It's quicker, it can be much cheaper. When you have to get an attorney for the child, where in Supreme Court you're going to have to pay for that in some proportion. Generally in family court, it's appointed. There are exceptions, but it's appointed. You don't have to pay for that. You might get a quicker resolution to custody or to child support than going to Supreme Court. But if it's a divorce, you have to go there. If it's a post-judgment application, let's say you get divorced and the house has to be sold at some point, and the husband's in the house and he doesn't want to budge, or the wife's in the house and she doesn't want to budge. That can't go to family court, because family court can't handle, not only can't they handle divorces, they can't handle issues of what they call equitable distribution. Things, a house, a pension, a car. Those things have to be handled in Supreme Court. So if you're going back to court and say, my wife won't sell the darn house and I got to take her back to court, we go to Supreme. Now, family court can handle a lot of issues that can normally be handled in a divorce. Like what? We said child support, custody, parenting time, guardianship, orders of protection. Now, orders of protection are generally not handled in Supreme. They can be, but generally they're handled in either family court or criminal court. You can have an order of protection involving a criminal case, or you can just run into family court if there's a family relationship, or boyfriend and girlfriend, child in common, mother, son, brothers, siblings, things like that. You can run into family court and deal with it. Now, there's also the integrated part. Judge Krecker in Suffolk County has what they call the integrated part. So let's say you have a divorce. And let's say during the divorce, or even before the divorce started, the husband pushed the wife and got an order, and she got an order of protection against him, and maybe a criminal case pending. Judge Krecker can pull those cases in and say, I'm going to handle the divorce, but I'm also going to handle the order of protection, or the criminal case, or the family court case. So it's one-stop shopping. It's good and bad in some ways. Sometimes things can get bogged down. When you go into court, it's a busy part, and then sometimes the DA is involved, so you got to take care of the custody case or the divorce, and then wait for the DA to finish conferencing and all that. But it's called one-stop shopping. The judge can handle it. It's called the integrated part. So those are the differences between Supreme and family court. Another important distinction that you need to know. There's a case called Polyandro v. Polyandro. That stands for this proposition. If, let's say, the wife filed for divorce on January 5th, 2020, and the husband, 5 days later, files for custody or files for child support in family court, that case will get kicked once let's say, I gave the example, the wife filed the divorce. The wife goes to court, has an attorney, says, there's a case pending in Supreme Court, Polyandro v. Polyandro, the case has to be kicked. That will happen. Let's reverse that now. The wife filed the divorce on January 5th, 2020, but the husband filed for custody or child support in December of 2019. Technically, that family court case can survive. There could be the divorce case, but the family court case can survive. Sometimes the judge or the referee or the support magistrate in family court will say, you know what, go to Supreme Court. You can handle everything there, but you don't have to, because the divorce case wasn't started first. But a good attorney will advise you as to what is your best move, because sometimes it is to go to Supreme. What if you go to family court and let's say you just feel that you're not going to get, a fair shake, or you feel that the support magistrate or the referee or the judge is against you in some way. It may not be accurate, but that's what you feel. Or it may be accurate. You might say, you know what, let me get out of here and go to Supreme Court. I got a better shot. Maybe, maybe not. Sometimes the expression, the devil you know sometimes is better than the devil you don't know. Not that I'm quoting judges devils, but that's an expression. It means the judge you have now, you know who it is. You know what you got, especially if your attorney practices in that part. But if you go to Supreme, you don't know. There are some judges where I'd rather not get in a particular case. And there are some judges that I'd love to get in a particular case. So you got to be careful. That's why make those decisions after you hired a good attorney, because you may regret it. Sometimes I get in on the case and it's too late. You made a decision, I'm stuck with it. I might not be able to get it back to family court, or to keep it in Supreme. Or if you sign a piece of paper in family court allowing a particular referee to handle the case instead of a judge, you're stuck with that referee. That might be a good thing, it might not be a good thing. So extremely important to have an attorney help you make that decision as to where you want to go. I call it navigate the waters of family court or Supreme. So very important. And what I said to you, I know you learned something, you picked some things up, but there might be, well, why would I go here, why would I go there? That's why you have an attorney. It's like if I watch a medical show, I might have an idea of what hip replacement is all about. That doesn't mean I would do the hip replacement, as a doctor. I'm not. But at least I have some more information. So those are the differences between Supreme Court and family court. Another question I get is, what is a law guardian? Now we call them attorneys for the child. It used to be called law guardian. When I was, years ago, when I was in private, well, I am in private practice, but when I was with a firm, I was an attorney for the child. It was called law guardian. Very similar job, except back then a law guardian could be more in a position to substitute their opinion, let's say, for a 10-year-old. Where now the attorney for the child, for a kid over 7, is basically a mouthpiece for that child. Even if the law guardian or the attorney for the child disagrees, they really have to go into court and say, my client, that 10-year-old, wants to live with dad, wants to live with mom. Now, the attorney for the child is not the final word, but they carry a lot of weight. They're going to carry more weight than I or the attorney for the other side. Why? Because they are looking out for the child. I know it might sound callous, but let's say in a divorce or custody case, I have the husband or the wife or the mother or the father. My job isn't to look out for that child. I don't want that child hurt, but my job is to look out for the parent, my client. The attorney for the child's sole function, just like when I was a law guardian and I was on the case, the sole function is to look out for the child or children. And they get to speak to the child or the children, depending on how old they are. I, let's say the attorney for the mother or the father, would never get to speak to the kids. I can't. Sometimes they bring the kid in, I say, hi, nice to meet you, have a seat. Nothing personal. I can't talk to them, nor can the other attorney. So the law guardian carries a lot of weight because they talk to the child, they understand the dynamics maybe better than I would because I only hear from my client. And my client could be telling me something that's not accurate. Oh, the mother's doing this, the mother's doing that, she's a drug addict, she's an alcoholic. That might not be true, but that's what my client's telling me. The law guardian could talk to, let's say the child's 15. Okay, tell me a little bit about when you're with dad. Tell me when you're with mom. Oh, dad's always drinking or mom's doing drugs. Then I get maybe a little more, as long as the child is being honest, I get a little better perspective than I would get just talking to one side. Just like a judge wouldn't make a custody decision only talking to the husband or only talking to the wife. There would be a trial if they couldn't settle it. And the husband would testify, the wife would testify, documents could be entered into evidence, witnesses can be called to testify, and the judge gets a sense of what this is really going on and makes a decision. Right? The attorney for the child is in a unique position to do that, whereas the attorneys won't. And at the end of a trial or a hearing, the children can be brought back in to see the judge. Now, sometimes it happens before, generally after. And they go back in a room, the judge's chambers. I'm not there, the other attorney's not there, the mother's not there, the father's not there. Who's there? The judge or referee, the attorney for the child, generally a court officer, a court reporter. That's who's in the room. So I never know exactly what is going on in that room, nor does the other attorney. Sometimes the kids say things, sometimes they don't. Some attorneys for the children are a little more forthcoming with information. They shouldn't say what the kid said verbatim, but they can say, it's pretty clear to me the kid wants to live with mom. Okay, that's not a secret because that's going to be their recommendation anyway. Also, the attorneys get to write up some questions. That doesn't mean that the judge or the attorney for the child has to ask those questions, but I could come up with a list of 10, let's say, and the other attorney comes up with his or her list. And they're given to the attorney for the child, and they go in the back, and the attorney can look at it and say, you know what, that's a good question. What happened when you went to Disneyland 5 years ago? Because maybe it's important to know. There was an incident or something like that. That's something that the attorney can ask, the attorney for the child can ask or not. And again, I may never know what exactly went in there. That's usually after the trial. The judge had heard all the evidence, and now he can put things in perspective. Because let's say he meets with the kids before. He doesn't really understand the whole dynamics other than maybe what the attorneys told him. But if he heard all the evidence, so I'll give you an example. Let's say mother and father testify about something that is a 180, totally opposite. And you have a 15-year-old, let's say. The judge can say, remember when you went to Disneyland? What happened? Now, not to feed the kid the information, but say, what happened? And let's say the kid says, we went to Disneyland in California, and mom did this that was inappropriate, or dad did that. Coming from the child. So the judge now can be in a better position to say, all right, the father lied to me, or the mother lied to me, assuming the kid is telling the truth. So that would only happen after the trial. Because if you did it before, you might want to meet the kid again, and you don't want the kid to have fond memories of meeting the judge on 3 occasions. So usually do it afterwards. Sometimes you do it before because it might help settle the case. Let's say you're dealing with a 15-year-old as opposed to a 5-year-old or even a 10-year-old. And the 15-year-old kid, who doesn't have absolute power but has a significant say, might say to the judge, Judge, I want to live with my dad. Because mom does this, mom does that, dad always helps me with my homework, dad's a great guy. The judge might go out, send the kid away, and then bring the attorneys in and say, look, we could have a trial, spend a lot of money, you guys can beat each other up, and I'm going to hear that kid at the end of the trial, and he just articulated a reason why he should be with dad, or mom, whatever the case is. If, let's say he said dad, and I'm the attorney for the mother, I might say to her, look, this is going to cost you $10,000, and this is an uphill battle. And if you lose, I lose the ability to negotiate. So maybe we're not going to get custody, but I could negotiate joint custody and a schedule that you can live with. If we throw it in the lap of the judge, you're not going to get joint custody in all likelihood. It's going to be sold to him. You might not get all the holidays you want. You might not get things that are unique to you. Like let's say you're a nurse and you say, I'm working every weekend. I don't want every weekend, or I don't want alternate weekends. I want during the week, whatever. If you go to trial, the judge might not give you what you want. And then I can't negotiate at the end because you lost. Or the judge already said something that might make it so that, why would the other side then come to the table? You roll the dice and you lost. All right? Now that doesn't mean I've never won a case where the law guardian favored the other side, but as an attorney, I'm going to advise you what I think. Do you want to spend all that money and probably lose? If the 15-year-old or 16-year-old kid is saying dad and can articulate a reason. Now, what if the 15-year-old says, I want to be with dad. Dad's real cool. He lets me do what I want to do. I don't have to do homework. I can stay up all hour. Whoa. Maybe dad is not the parent for this child to live with because he didn't articulate a reason. If anything, he articulated a reason against living with that dad because mom might be the disciplinarian. Mom might ensure that that child goes to school and gets good grades and maybe doesn't do drugs and doesn't stay out all hours of the night. Where dad will allow that. But people tend to, kids especially, want the path of least resistance. It's almost like a politician that promises you the world where the other politician said, you're going to have to work hard for that. And the other one says, free this, free that. What is a voter going to do? Oh, I want the free stuff. Well, a 15-year-old kid would want the free stuff, would want a lot of leeway where mom might say, no, you're not going out that late. You're going to do this. So the judge has to be careful and say, and also the attorney for the child, say, why do you want to live with dad? It shouldn't be, okay, come on back. Where do you want to live? Dad, okay, we're done. No. It's got to be more thorough. And these judges know what they have to do. What is another frequently asked question? And maybe they don't ask it this way, but it has to do with discovery or disclosure. Remember my cousin Vinny? And I showed you my cousin Vinny before. Well, in the movie, he goes hunting, he comes back, and he says, I'm finessing him. I let him, he let me look at his files. Trotter let me look at his files. And she said, he's supposed to, he has to. It's disclosure, you D-head. Remember? What she was saying is, he has to. That's called disclosure. Now, in the movie, it wasn't until Vinny, or Jerry Gallo, or Jerry Callo, remember he changed his name when the other guy was dead? He said, it's my stage name. He asked the DA for discovery. Had he not asked, he wouldn't get it. So it's not automatic. In a divorce case, let's say, as the attorney, I'm going to say to the other side, I want to see his tax returns. I want to see business records. I want to see all these things. Now, that doesn't mean, and I see it too often, where the attorney sends me a 30-page document, I want this. Why don't you tailor it to the particular case? If you're dealing with a couple that's two W-2 people, right? One's making 50, one's making 60. Why do you want to hit them with, do you have a business? Do you have chattel? You don't need to do that. You can do it in a more user-friendly way. Because if I have to send that out, then I'm going to have to read it when I get back. It's going to cost you more money. And there are times when you need to do that. Let's say somebody owns a business. Well, then you might need to be more specific, or you might need to ask extra questions. You might need a deposition. You might need to subpoena records. Not all the time. If it's a couple, like I said, W-2, one's a cop, one's a nurse, they own a house, you don't need to go crazy, because that's only going to cost the parties more money. So discovery is what you want from the other side. Like I said, tax returns, business records. It could be bank statements, credit card statements, a W-2. We're at the time of year where people are getting a W-2. I went to court today and I said to the attorney, did your guy get his W-2? Yeah, I'll get it to you. I need to see that, because his income might have gone up from 2018. It might have gone down from 2018. I need that information. And it's too early in the year to get a pay stub and extrapolate from January 20th to the end of the year. Give an example. Let's say it's December of 2020. And I look at his 2019 W-2 and it says he made 50. And then I say, okay, I know he didn't get his W-2 yet. Give me his most recent pay stub so I can extrapolate. What do I do with, what do I mean by that? Let's say it's December 20th. I get his pay stub. And his pay stub says year to date, $60,000. So I know with maybe one paycheck left, he made $60,000. If I just went by his W-2 for 19, it would say $50,000. But now I know he made $10,000 more. And maybe you don't want to wait for the W-2, because I won't need to. The pay stub will tell me what he makes, year to date. If you get it in October, you extrapolate. All right, what did he make for 9 months? Okay, November, December, or 8 months, or 9 months, 10 months, whatever it is. Say, okay, through October. So there's still November and December. So I can calculate what he made for, let's say, 10 months, do the math, and say, okay, he's on target to make $12,000 a month. Then I times it by 12. Okay, so then I know he makes $144,000, or whatever the case might be. So disclosure, discovery is extremely important. Now, sometimes people don't cooperate. You say to your client, get me this. I don't have it, or I don't. Then the other attorney is going to have to jump through hoops. And if they can prove that they're jumping through hoops, you might get hit with higher attorney's fees, especially if you're the moneyed spouse. So cooperate. Don't try to be cute. Don't try to hide the information. It's going to come back to bite you in the butt. Don't do that. Another question I get asked often is, what is a quadro? Qualified Domestic Relations Order. If you're going through a divorce and somebody has a pension, or somebody has a certain retirement account where you can't just divvy it up. Like, let's say you had a brokerage account. That's easy. The brokerage account is $100,000, assuming it's all marital. You say, you take 50, I take 50. But if it's a pension, you can't do that. you have to have a Supreme Court judge, not even a family court judge. A Supreme Court judge will sign what they call a DRO, Domestic Relations Order. It becomes a qualified domestic relations order. That document is an order. That gets sent, so let's say a guy's a cop, and he's going through a divorce and he says, I want to give my wife half the pension. Can he do that? Yes, but he has to have a quadro. So the pension company or the pension fund would get the quadro signed by a judge, and it says the wife is to get 50% of the marital portion, blah, blah, blah. So then the pension company sets that up for the wife. So when he's in retirement, he gets his share, she gets her share. Doesn't mean it's equal because he might have been a cop 5 years before the marriage. So the marital portion is what they call like the Majaskis formula. There's a numerator denominator. So let's say the guy was a cop. He started being a cop in 2000. And he got married in 2010, going through divorce in 2020. The marital portion is 2010 to 2020. What happens to the 10 years when he was a cop, when he wasn't married? That's his separate property. So a company, no attorney in his right mind would do a quadro. We hire a company. It's only about $600. We hire a company to do that. They will tell us, we tell them the dates and all of that, and they take it from there. So quadro is when there's a pension or something like that. Sometimes you could do a rollover. So let's say there's an IRA and you might not need a quadro. The wife would run to, let's say, Charles Schwab, set up an account, and 50% of the IRA, let's say, or 401k, whatever it is, would go into that account. But sometimes you need a quadro, and that's what that is. Another question I get often, in fact, I've done whole shows on equitable distribution. But a question I get is, what is the difference between marital property and separate property? And it's an important distinction, and you need to know. Because how do you divide up the marital estate if something's not marital? I'll give you an example. Let's say a parties get married, and the husband owned a house before the marriage. And during the marriage, he didn't put his wife's name on the deed. No marital funds were used to fix the house, to pay for the house. It had a renter, and it paid for itself. Now they're going through a divorce, and the wife says, I want half that house. She's not getting half that house because her name was never put on the deed. It wasn't purchased during the marriage. If it's purchased during the marriage, there's a presumption that it's a marital asset. But in the example I just gave, she wouldn't be able to touch a penny of that house. That would be his separate property. Now, let's say in that same example, he bought the house years and years. Let's say he bought it in the 80s, doesn't matter, years ago. If he put his wife's name on the deed, then it becomes marital. There's a separate property component and a marital component. Now, remember I said I try to keep things simple? These are things that get a little complicated. That's why you need a good attorney to say to you, okay, give me all the facts. When was the house purchased? In whose name? Did it become transmuted? Meaning, was the wife's name put on the deed? Now, sometimes bank accounts, they talk about commingling. In other words, I have a bank account with $100,000. I get married. During the marriage, I put my wife's name on it. I'm commingling the funds. So you have to know, is it transmutation? Even courts get it wrong. I go to this seminar, great seminar. And the guy who runs this seminar says even appellate courts get it wrong, where they talk about it was commingled when it was really transmuted and all of that. I once used that issue to save my client a lot of money because the attorney he had wasn't analyzing it properly, because in the transmutation, you need two values. What was it the day the wife went on the deed? What is it now? If you don't have two values, the court can't give a separate property claim. That's why it's important to know the difference between marital and separate. So generally, if it's purchased during the marriage, it's marital. Or it can become marital when a husband puts his wife's name on the bank account, the car title, the deed to the house, the timeshare, any of those things. All right? Now, I'll give you an example where something is purchased during the marriage. There's a legal presumption it's marital, but it won't end up being marital. Let's say a man owns a house and he's not married. Then he gets married, and while he's married, he sells that separate piece of property. Remember the example I gave? No marital funds were used to fix it. No marital funds were used to pay for it. He owned it prior to the marriage. He sells that house. And let's say he sells that house for $300,000. and he takes that $300,000 and he buys another house during the marriage. Now, what did I just say? There's a presumption. It's a rebuttable presumption. Just because it's presumed marital doesn't mean it'll end up that way. Because then they get divorced and the wife says, that house was purchased during the marriage. Okay, it's marital. Can the husband rebut that presumption? Yes. Here's the closing statement. I sold that house, which is clearly separate, and I bought a house for $300,000. I didn't use any money, marital funds. I used the money that I had prior. Or the same as an inheritance. Let's say during the marriage, he inherits $1 million. The wife can't touch that unless he commingles it. So he wins $1 million, he puts his wife's name, or he puts the money into an account. And it's not just for a matter of convenience. It stays there for years. The wife can draw the money, he can draw the money, they buy things together, they buy things separately. That $1 million lost that, or whatever's left of the million, lost its separate property feature. But let's say the guy inherits $1 million and he buys a house for $500,000 using that money. And he doesn't put the wife's name on it and no marital funds are used. That is a separate piece of property. Very quickly, I see we're running low on time. What is wasteful dissipation? This comes up more often than you might think. Wasteful dissipation is where one spouse wastes an asset. It could be, let's say the guy's a gambler and he just gambles money away and he gambled $50,000 away. He would probably have to give the wife $25,000, which would be her share. So he gives her the $25,000, he just made her whole. Or let's say the guy takes the money and he buys his girlfriend a ring, or he buys his brother a truck. That could be considered wasteful dissipation because that was a marital asset that he inappropriately used to get rid of that money, either secretively or not so secretively, to give that money to somebody else, or the value or an asset to somebody else. That would be wasteful dissipation. Or let's say the guy buys a penny stock that is clearly a gamble and he loses money. The court could say, no, you wastefully dissipated assets. Now, if he bought a legit stock, let's say he bought a Washington Mutual or something like that, or Wells Fargo or something, and they go out of business. That wouldn't be wasteful dissipation because that wasn't something that really could be easily anticipated. So when you see your attorney, if you think your spouse wasted assets, tell the attorney and he can analyze it. In closing, I wrote a book called Divorce: A Practical Guide. If you want to take a look at it, you can get it. You go to my website, JussinoLaw.com. It's a great read. It'll give you information that will make you a better consumer when you talk to an attorney or when you go to court. So even if you didn't hire an attorney, which I'm not advising, that would give you information. Or better yet, you're better informed so that when you go to the attorney, if you read the book, you can say, okay, I know what wasteful dissipation is. Or you saw my show. I know what a quadro is. So you can have a better, intelligent conversation with the attorney. So if you need to get a look at that book, you can go to JussinoLaw.com. At the end of the first page, you can go to that. You can take a look at it. There's some excerpts in there. You can see what you're missing if you don't read the book. There's this expression, sometimes you don't know what you don't know. When you read the book, you'll know. I'd like to see you next Saturday at 10 a.m., channel 115. I'm attorney Phil Jussino. This was Finding Common Ground. Thanks for watching. You have a good day.